Hello, welcome to the Virtual Hammer Museum, coming to you live from Los Angeles. I'm Claudia Bester, and I'm the Director of Hammer Public Programs, and I'm pleased to welcome you to today's Hammer Forum on the recent Supreme Court decision about the Consumer Finance Protection Bureau. Before we get started, I have a few notes for the audience. This program is being conducted via Zoom webinar, and we cannot see you in the audience, and we can't hear you. We can just see your names and anything that you type into the chat box and the Q&A box. So we'd love for you all to introduce yourselves in the chat box and tell us where you're tuning in from, and you can also talk to other audience members in the chat. The Q&A box is where you type in questions you have for the panelists. Please note that this program is being recorded and it will be available later on the Hammer website. And if you'd like to receive reminder emails about our upcoming events, please sign up for our email list, also on the Hammer website, where you can find recordings of most of our past public programs as well. So on to today's program. The Hammer Forum is a monthly series of public discussions about current social and political issues, and it's made possible with support from the Rosenblum family. A month ago, on June 29th, the Supreme Court decided on a case which asked, was the creation of the Consumer Financial Protection Bureau constitutional? The case was brought to court by a company called Sila Law that was under investigation by the Consumer Financial Protection Bureau, or CFPB. Congress created the CFPB as an independent agency in 2010 to protect consumers from abuses in the banking and financial services industry that led to the 2008 financial meltdown. But in order to ensure the CFPB's independence, the terms used in creating the agency called for it to be headed by a single director confirmed by the Senate, who would serve a 5-year term and who could only be fired for malfeasance, inefficiency, or neglect of duty. Sila Law claimed that the CFPB never should have been formed in the first place, and the Supreme Court's final ruling was kind of a mixed decision. It's a confusing and complex case, and I've probably bungled it already, but luckily our brilliant panelists will explain it to us and get into why it matters. Our first guest is constitutional law scholar Charlton Copeland. He's a professor of law and distinguished scholar at the University of Miami Law School, where he teaches administrative law, civil procedure, federal courts, constitutional law, and the regulatory state. His scholarly and research interests primarily focus on separation of powers and federalism. He's written in the areas of state sovereign immunity, Medicaid, and other cooperative federalism policies, the relationship between state courts and federal law, and the separation of powers. And he's currently researching the politics of the Republican Party's abandonment of the Chevron doctrine. Our second speaker is Jennifer Taub. She's a professor of law at Western New England University School of Law and a leading authority on the 2008 mortgage meltdown and related financial crisis. Her reading and writing centers on follow the money type matters, promoting transparency and opposing corruption. Her new book will be published on September 29th by Viking Press, and it's called Big Dirty Money, The Shocking Injustice and Unseen Cost of White-Collar Crime. Taub's prior book, Other People's Houses, How Decades of Bailouts, Captive Regulators, and Toxic Bankers Made Home Mortgages a Thrilling Business, was published by Yale Press in 2014. She's also a co-author of the 6th edition of Corporate and White-Collar Crime, Cases and Materials. Taub's scholarly writing on corporate finance, financial market regulation, and banking law reform has been widely published, and she's testified several times before U.S. congressional committees, including the Senate Banking Committee and a House Financial Services Subcommittee. Our moderator tonight is Loyola Law School professor Jessica Levinson. Levinson studies the law of the political process, including election law and governance issues. Her work focuses on ethics, political corruption, voting rights, campaign finance, ballot initiatives, redistricting, term limits, and state budgets. She regularly appears as a legal and political expert on television and radio and in print. She's the host of the new podcast, Passing Judgment, and has a weekly legal segment on NPR member station KCRW here in Los Angeles. She's also an op-ed contributor for NBC.com and the associate director of Loyola's Journalist Law School. Professor Levinson served as the president of the Los Angeles Ethics Commission until 2018. She's also the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. So please join me in welcoming Jessica Levinson.
Hi, everybody. Thank you so much. So I've changed the orientation of the room to give you a little bit of a set change. And I'm so happy to see a lot of familiar faces. Today, as Claudia said, we're going to be talking about a really important case and a really important issue. Executive agencies, the administrative state, and specifically the Consumer Financial Protection Bureau. So I'm going to get to our amazing panelists really quickly. First, we're going to do what we usually do here, call up our very short slides. And the first slide is just what we're doing here, checks, balances, and the future of the Consumer Financial Protection Bureau, and really the future of this thing called the administrative state. And so the next slide, I just want to give everybody a roadmap for where we're going and what we're going to do today. I want to talk about what is the Consumer Financial Protection Bureau, why was it created, when was it created, how does it function or how does it work, what powers does it have, why is it important that the Consumer Financial Protection Bureau, why is it important to this executive agency to have a, quote, independent director? And what does independent really mean? Then, because this is part of our Supreme Court series, of course, talk about the Supreme Court case. What was the question before the court? What did the court ultimately say? What were the dissents? And then going forward, and this is something we always want to do in all of our HAM reforms, what does this mean for your daily life? What does this decision mean for Americans who, many of whom have mortgages or loans, and obviously the Consumer Financial Protection Bureau affects all of those things, in addition to what does this mean for other executive agencies? And so with that, I'm going to ask for the slides to come down and our wonderful panelists to come back up. So Jen, first question. What is the Consumer Financial Protection Bureau and when was it created?
So it's an agency inside of the Treasury Department, and it was created as part of the Dodd-Frank Act, which is that big law that passed in 2010 after the major toxic mortgage-backed financial crisis that many of us still remember. And it was created, I believe, not just to protect consumers, but with the recognition that consumers are like canaries in the coal mine when it comes to our banking industry and our financial sector. And when consumers were being hurt, no one was listening to the consumer advocates for years and years. And what we came to find out is that when banks engage in predatory lending with consumers, that means they're originating mortgages and putting those on their balance sheets, and the banks become riskier and riskier. So in part, the Consumer Financial Protection Bureau was created to protect consumers, but it's also to prevent another, bailout like we had in 2008.
Which, of course, it's somewhat of an ironic day to be talking about this. They're not directly related, but we had historically low GDP numbers come out today, which is why I think we're talking about whether or not the President of the United States can delay the election, which I suggest we do in kind of a lightning round at the end of our panel right before Q&A. So Charlton, how does it function? So the Consumer Financial Protection Bureau, it's part of the sweeping financial legislation, Dodd-Frank, and it is, what specifically is its structure? And I know when I researched this, it's quasi-judicial functions, quasi-legislative functions. Can you explain to us, what does that really mean?
Sure. So one of the things that Dodd-Frank did in creating the Consumer Financial Protection Bureau was to hand over to it statutes that had basically been spread across a host of agencies, right? And so there was a sense that, as Jennifer said, consumers were going to be better protected if they had an agency that was actually going to not have to compete with other agencies, right? And in some sense, that part of the sort of problem and the holes in the regulatory safety net, as it were in part because Agency A had a piece of some statute, Agency B had another piece of some statute, right? Financial institutions sometimes could shop around, under whose regulatory authority they wanted to rest, right? And so they wanted to kind of unify that in a single agency, and then gave them the regulatory authority to enact rules, right? Which are basically the same sort that Congress writes, meaning if you violate those rules, you violated federal law, to give individuals the agency the right to enforce violations of those rules. One of the most important rights was for the agency to actually go to court and sue bad actors. The authority given to the CFPB that actually gave rise to the Supreme Court case that we're going to talk about was investigatory power, right? That this case sort of stems from the agency attempting to pursue a subpoena in an investigation. And so the agency had a broad swath of authority. Let me say something in disclosure. I actually benefited from a civil action that the CFPB instituted against Toyota Finance, right? And so one of in a racial discrimination suit that the DOJ and CFPB brought, they sued Toyota Finance for discriminating against African Americans and Asians in interest rates. And so again, significant rulemaking authority, significant enforcement authority, but housed in some sense in one organization.
Yeah, Charlton, it shows what a big and complex agency it really is.
Yes.
So at the risk of beating a dead horse, Jen, can you explain to us, Charlton just explained perfectly all the things that the Consumer Financial Protection Bureau can do, the rulemaking, which is quasi-legislative, the investigation, the going to court. Can you explain, give an example of maybe one of the kind of highlight examples of what the Consumer Financial Protection Bureau did that we see as a victory, maybe from kind of start to finish? Like, how does it begin that we say, yes, this is a Consumer Financial Protection Bureau issue? And then what happens next?
Yeah, I want to pick up on what Charlton said to answer this, which is it has kind of, end-to-end power, everything from the making rules that financial institutions like lenders have to follow, to doing the investigations, being able to issue subpoenas. They can even bring their own administrative actions in their own courts, but then they can also go to federal court. So before I say an end-to-end example everyone will recognize, I want to throw some numbers out at you. I mean, Charlton is a success story. He was someone who the agency represented, but we're not just talking about one guy who's a lawyer who was in on some good stuff. We're talking about over 25 million Americans, and I think it's now over $12 billion returned to them in restitution. Very impressive. So an example would be Wells Fargo, right? The poster child of banking problems, once thought to be one of the good banks, right? If we rewound to 2008, we would have thought Wells Fargo was one of the banks that supposedly was less predatory, gave out better home mortgages. But it turns out they, as many people know, were creating millions of bank accounts and credit card accounts without customer authorization. There's much more that they've also been gotten in trouble with as well. But this is an example of the CFPB finding this out, investigating, getting a settlement in the millions of dollars from them, and orders so they don't continue that. Also, I will say the CFPB's power is so exacting that as soon as this investigation that it came out in the news, there were 2 congressional hearings, and there was a bipartisan effort. You don't usually see a hearing where it's not a circus, where everybody's actually focused on questioning the wrongdoer. And we had the CEO of Wells Fargo a couple of falls ago in the hot seat. And I remember telling my students who were studying white collar crime at the time, this guy's going to resign in 30 days. You could just see it. So it has a bully pulpit effect as well.
Can I just say, what an America 2020 comment. It's rare to see a hearing that's not a circus. I mean, or, also 2019 a little bit, but that's a great example of the broad reach of the Consumer Financial Protection Bureau. So I think we walked through what it is. When it was created, I always think of it as really being birthed out of the Great Recession, and the idea that we have to, I think of it in maybe too simplistic terms, that we have to protect consumers against private businesses that behave badly. I know that's kind of an extremely 30,000-foot view of it. Yeah.
And I just want to add one thing, which is one other thing that you're saying about it, Jessica, and also Charlton, is housing these powers in one agency was important because of what we've seen over the years, not just under the Trump administration, of regulatory capture. So before, if you had some banking, depending on how a bank was regulated, there are several banking regulators, depending on where the business was regulated, that's how all the enforcement authority was split up. But the same people who show up at the banks, who talk to them, who get wined and dined, were also supposed to be protecting consumers. And it just wasn't their mindset. And so the idea was to create an agency whose entire mindset was consumer protection, period. And there is one, the Federal Trade Commission, but that didn't deal with financial products. So this was supposed to be the equivalent, I believe, to the Federal Trade Commission.
And this was, of course, I think of it as the, I guess, third child of Senator Elizabeth Warren, where she talks about the Consumer Financial Protection Bureau, like she says, like her baby. And she, Charlton, maybe you could walk us through for a moment. I think she was actually, Senator Elizabeth Warren was floated as perhaps the first director. Could you take us on a slight detour and maybe remind us what happened?
No, I mean, I think that one of the story in some sense of the fragility of the CFPB,
yeah,
I think is important. And I think that Elizabeth Warren's failed attempt to get named as chair of this agency that she had tried to back is part of that fragility. And so I think it's absolutely apropos. So, Elizabeth Warren is teaching at Harvard, and she's writing about bankruptcy, but she's sort of seeing the stories behind bankruptcy, right? And she's saying, look, we've got a system that is putting too much on consumers, that's not informing consumers. And to go back to Jennifer's point, that's creating systemic risk, right? That we are creating the sort of systemic risk that is making our economy more fragile, more vulnerable for these sorts of systemic catastrophic events, right? And so again, like so much in the American regulatory state born out of catastrophe, she says, let's do this. Let's push this agenda forward, right? And if you think about the CFPB, right, it is one of the victories of the crash, but it is also a victory on a field that was littered with lots of other, I think, big regulatory agendas, right? Breaking up big banks, right? Limiting certain kinds of investments they could make, right? The sorts of things that you heard from Paul Volcker early in the Obama, or even before the Obama administration and early in the Obama administration. And so you get the CFPB, you get Dodd-Frank, but you get a kind of intransigence about who is going to lead it, right? And I think there was a sense that she should not be the head, that that in some sense she was too involved, and so the administration, I suspect for any number of reasons, picks Richard Cordray to lead the administration, who to lead the agency, it's history. Elizabeth Warren decides she wants to write the next laws, not sort of simply advocate those. But I think the extent of the reform in some sense says here and no further, right? We'll give you Dodd-Frank, we'll give you the CFPB, but you're not going to get Elizabeth Warren, right? She's been the sort of advisor to the president to get this here. And I think it's emblematic of the compromises that were made sort of on the way to implementation of this.
You said so much of regulatory reform is born out of crisis. And I would just say, same for a lot of legislation, right? I mean, I'm thinking about election law.
Right.
You really don't get comprehensive election law until you get President Nixon resigning in what is a campaign finance scandal.
Right.
But I mean, it's such a good and broader
and more separation of powers.
Yeah, exactly. So I guess that does bring us a little bit closer to the case. So we've been talking about the creation of the Consumer Financial Protection Bureau, what it does, that it's really this place where you kind of centralize all of these really important concerns and powers, and that it's important that it not be fragmented and decentralized. And we talked a little bit about one of the big highlights or wins for the Consumer Financial Protection Bureau. And Jen laid out, how many people are affected by it. And then the political turmoil of who the first director is. And I think that brings us to getting a little bit, this leads us into the case, which is, how is the agency structured in terms of, I think, Jen, this is the next question is to you. I'm just going up and back in no good order, which is, how is there one director? Is there a couple of directors? And previously, how could the president fire this director?
Yeah, so before June 29th of this year, it had one structure. And then after the Supreme Court decision, we have a different thing. So let's talk about the pre-Supreme Court decision. The agency was set up to have a single director appointed by the President of the United States with advice and consent of the Senate. So just like we see these hearings for Supreme Court justices or for certain cabinet appointees, that's how the consumer agency director was appointed. So that was initially Richard Cordray. How this differs from some other agencies, I mentioned earlier, the Federal Trade Commission, they have a board, or the Federal Deposit Insurance Corporation, which is the one you may see if you are worried about a run on the bank, the FDIC has a deposit insurance fund. Well, they have a board. And the difference is with there's structural difference, but there's a political reason for it. So the structural difference is with those agencies that have boards, typically if there's five seats on the board, only 3 can be one political party, and they have staggered terms. Whereas with a director, has in this case would have a 5-year term. And importantly, the reason why this was chosen is to make it more powerful. Anyone knows that if you have all the power, decisions will be made faster. The minute you put someone else in the room, who knows what you're having for dinner, right? Anyone who has kids or a partner knows that, it's always nice to have someone, but if you want to get something done fast, you don't ask people. And that was exactly the concern folks had. They felt that there wasn't enough oversight. Now, keep in mind, because as a part of Treasury, the budget came through that. So of course, if the president wanted to cut off the funding, a president could. But the last piece of this, so that you didn't exactly ask it, Jessica, but I think it's important, is with this director, the president could only remove the director for cause. And the language is for inefficiency, neglect, or malfeasance. And that standard is similar to other agency heads who are part of a board. But that standard, the concern with that standard was, wait a second, the president can't fire this person. And this was the concern the Supreme Court was addressing.
So Charlton, we'll continue the story with you. So Jen lays this out perfectly, which is you have this director of the Consumer Financial Protection Bureau, and the president cannot fire the director at will. That's the key part of the case, right? Which is SELA law, this group that was actually being investigated, as we said, by the Consumer Financial Protection Bureau. Their response in part is, I'll see your investigation and I'll challenge your entire structure. And so we have this standard where the president can only remove the director, again, for inefficiency, neglect, or malfeasance. That sounds rational to me. It sounds like it's okay for the president to have to point to some reason. And frankly, that sounds like a fairly low standard. It's not that you committed a crime or it's not recklessness. So can you explain to us what's the crux of the legal problem here?
So in some sense, the legal problem extends back to, Marbury versus Madison in some sense, right? This notion that
for the audience, can you just
Marbury versus Madison is that historic case involving the failure of the new Secretary of State, James Madison, to deliver an appointment that had been made by the outgoing President John Adams, and there, right, the court initiates what we call judicial review, right, which is its claim to fame. But in that opinion, the court talks about what it means for the president to be able to name officials, what it might mean for the president to not be able to get all of the people that the president names, but raises this question about what it means for the president not to be able to remove people, right? And so this sense of the failure or inability for the president to remove might be a greater hindrance on the president than not to get the person you want initially, right? And so you know, if people are fungible, I know that we believe, you know, that only one person can do a job, but you know, people with big egos, but that's, you know, the jurisprudence says no, you're fungible. But if the president has someone in his or her administration that in whom they have lost confidence, it shackles the president not to be able to say, hey, can we go our separate ways? Don't you want to go home and spend more time with your family? And so, right, this is, as the opinions say, this is a story of the entire history of American governance, right? The issue here is that a president who does not have the capacity to remove officials in whom he does not share a kind of policy alignment is in some sense has lost control of the policy agenda. And right, more recent cases seem to suggest, and that the president is uniquely vulnerable, right? That is, the president, chief among everybody else, is going to be held accountable for the sorts of policies that are attributed to his administration. And when the president loses that control, and the control is understood as the ability to remove, right? And so it hinges on saying removal is fundamental to control, right? And that control is fundamental to what the framers conceive of as the president's ability to govern as the Constitution sees fit.
Yes, and I was waiting for our Marbury versus Madison reference. I had it on my bingo card tonight. Thank you for fulfilling that. Jen, let's stay with the legal issue for a minute. So the president might not be able to say, you know, again, that don't you want to spend more time with your family? Is there a specific clause in the Constitution that CELA law is pointing to kind of hang its hat on the president? I see you came with receipts, as we say nowadays.
Oh, so the answer, that was a visual illustration that, yes, professor, I know the answer. So it's, here's my handy, I have many of these. This one's a little dog-eared. This is my pocket Constitution and Declaration of Independence. They even threw in the Gettysburg Address from Free Speech for People. Little plug for them. Anyway, so it's Article 2, Section 1. And for those not as familiar with the Constitution, Article 1, it lays out the powers and responsibilities of the legislative branch. And Article 2 is the executive branch, and 3 is the judiciary, right? So what's interesting about Article 2, Section 1, Clause 1 says, the executive power shall be vested in the President of the United States. So that's the main clause. Also, there's another clause about taking care to make sure the laws will be enforced. But they point to that and say, you know, if this is a lesser officer that the president has appointed and high enough up, and it was so much power, because they say, look, not just the structure, but as Charlton started out by saying, you know, this is an agency that does a lot of things, regulates a lot of businesses, so much power appointed by the president needs to be able to remove them just for any reason whatsoever. Could be personality, could be policy, any reason other than something that would be otherwise unlawful, like unconstitutional, like race or gender discrimination.
Which we know from Our Lady of Guadalupe, for those Hammer participants playing at home, might actually be permissible in a religious institution. But I do digress. So Charlton, back to you. It did feel like a lot of this case hinged on that take care to faithfully execute the laws, provision of the Constitution, that it's only the president who has the power to take care. And can he really do that if he can't just say, I don't like your hair color, director of the Consumer Financial Protection Bureau, you're out. But so let me play devil's advocate for a little bit. I hope it's a fair question, which is, it seems like a pretty low standard to just say you're not efficient, or you're director of the Consumer Financial Protection Bureau, you're negligent, or malfeasance, I think, is higher. But did it, is there an argument that it doesn't really hinder the president's ability to take care to faithfully execute the laws if he just has to point to something? I mean, it feels like a fairly low bar.
Well, I think that the jurisprudence suggests that it can't be solely based on policy differences, right? That in prior cases, the courts have recognized that those constraints on the president's power are real, and that they amount to more than sort of trivial differences of policy. And so in that respect, I think the challenge to the CFPB is correct, right? That is to say, the constraint on the president's removal of authority, at least when we take the jurisprudential line, is a serious constraint. The question that arises, and this sort of depends in terms of what you want to emphasize with respect to the line of cases. This is to go back to what Jen said earlier. In the line of cases that we get, in Humphrey's Executor, the case in which Franklin Roosevelt says to Commissioner Humphrey, hey, I kind of want somebody who I think probably is going to vindicate my policy views better than I think you are likely to do. Let's part ways, have a good life, right? And he says no, and we go to court. The court in Humphrey says, look, the president can not remove those officials who do not exercise executive authority, right? This comes back to your first question. What sets of authorities does the CFPB exercise? When I said to you, the CFPB went after Toyota, they initiated an investigation into Saylor law, right? These are executive functions, right? So they when they make rules, they begin to look like legislative bodies. When they adjudicate violations of those rules, they begin to look like adjudicative bodies. And so the court in Humphrey says about the FTC, this is not an executive agency. They don't perform executive functions. They perform quasi-legislative, quasi-judicial. And so they can't be removed, right? Leaving this notion that when you are an executive functionary, you can in fact be removed. Fast forward to, again, those cases and rules that come out of the Nixon administration, the Ethics in Government Act, which creates the independent counsel. The court there says Congress can in fact impose constraints on the president even when the agency official is exercising purely prosecutorial, that is to say, purely executive functions. And then to go back to what Jen says, but the caveat is that they can't impinge upon the president's capacity to do the president's job. And so now we're asking this question, so how do we understand the CFPB? Is it an agency that is infringing upon the capacity of the president to do his job? This goes back to your point just a second ago, Jessica. The CFPB is doing it all, right? They're writing rules. They are taking people to court. They are getting they are helping 29 million people. They are disgorging $12 billion, right? This is not insignificant, meaning this is not, the argument goes, the same as a prosecutor. I don't care where the prosecutor is, and I don't care whether it's the president or not. The court in that case says the prosecutor's function is sort of narrow, right? It's just to sort of see, did the president violate this statute, or did somebody in the executive violate? But here, this is kind of regulatory across the broad swath of the American economy, right? And so this begins, the argument says, to have the capacity to infringe on the president's exercise of authority in ways that an independent counsel wasn't understood to infringe on that authority.
Jen, I see a hand.
So Charlton is so good because he teaches constitutional law, and I want to repeat what he said in simpler terms to make sure I have it right, and my friends who are following along do too. So when he said line of cases, correct me, Professor, if I'm wrong about this, but what he's saying is, there are some cases in the past where the Supreme Court said it was fine to have certain agencies or certain positions where the president was restricted and could only remove the person for cause. And the cases he gave an example, but the one from the post-Watergate era was the independent counsel, and the court had a justification why that was, an exception. And then we've had in the case from Roosevelt, the Humphreys executor. In that case, again, the court was fine with some of the president being limited, having his power of removal limited. So of course, I shouldn't say, of course, the Consumer Bureau, what they wanted, because they were there was an amicus here. But anyway, of course, anyone who would want to, for a person who wants to defend the old structure of the Consumer Bureau, having a single director with all these powers, they looked at those lines of cases Charlton just told us about and said, look, we're just like those cases. Right. But because of what you just said, where the court is here, is they're saying, well, you really like those cases or something else. So, is that right?
No, that's absolutely right. Absolutely.
I was hoping for some more fireworks between the panelists, but if you want to be, no, not at all. As I said, I just want to have fun and talk about, I know that have fun in the Consumer Financial Protection Bureau might not be the first thing everybody thinks of, but I think it is really important to, we read about these cases and these agencies feel kind of removed from our daily life, and then to ask, what are they really doing? How are they structured? Why are they being challenged? And so coming back to the case, it seems to me like we were kind of balancing two things. On the one hand, it seems that we want a director with some independence, in part because we don't, let's say Wells Fargo had started one of the biggest super PACs in favor of President Trump. And the Consumer Financial Protection Bureau starts investigating President Trump. Do we want him to be able to say, I'm firing the director because I don't like, is that basically, Jen, is that basically the idea behind the independence, that we don't want the president to say, I don't like you looking into Wells Fargo because they helped me with my reelection, or, with respect to this president because the Trump organization does a lot of business with them? Is that basically the idea that we don't want the president meddling with what the Bureau is doing?
I think so. And I also think there's this charitable view that in the abstract, let's just pretend, we'll call it a president, no political party, and a director. In a utopian world, you would think that any president would be pro-consumer because more Americans are consumers than, business, CEOs or and so on. And you would think that anyone who would be appointed to the agency would be pro-consumer. And so but that's not really, that world doesn't exist. And so there was a fear that a president who was pro-consumer would put in a pro-consumer, director, and a new president would come in, doesn't like consumers, and want to fire them. So the idea was to try to not allow that to happen as well. And unfortunately, sometimes this does align by political party, but not always. So I think that was the thinking. And of course, At the time the Bureau was created, we had President Barack Obama who supported the Bureau. And the thinking was he would put someone in who supports consumers, and he did, Richard Cordray. Of course, our world's been turned upside down, and it's hard not to see, to chuckle a little bit here about the irony, because now that they've put in, two different people Trump has put in people to lead the Bureau who wanted to take the word consumer from the beginning of it, the name, and put it at the end. And they're not really consumer advocates at all. If you've watched any of those, any of the hearings with the current director, I don't believe she is, and her term does not end until, 2022. So ironically, this decision, which I think many consumer advocates would decry, turns out in the real non-utopian world to be quite an interesting one, because it means if, Joe Biden is elected, he can immediately say, you're out of here, and have Professor Copeland run the agency.
And this is a point that I want to I want to emphasize again, which is this decision gives more power to presidents, not President Trump, to anyone who's in the Oval Office. And this is something that I try and emphasize with my students. And this is something that, Jen, you brought up to me earlier today, and I'm glad that you did, which is, it's this question of not, do you want President Trump to be able to fire somebody at will or to have to point to a reason? It's, do you want whoever's in the Oval Office to have to point to a reason that they're firing the director of the Consumer Financial Protection Bureau? But that's, of course, a policy question. And we haven't, Charlton, finished with the legal question. But I'm sorry, did you want to add Charlton, did you want to add something before I?
No, I actually think they converge.
Okay.
In some sense. That is to say, the dissent says, and this goes back to Jen's point, right? This is, so how does the CFPB look like those organizations that the court has said, hey, Congress can impose constraints? And in a really interesting dissent, Justice Kagan says, in the financial space, routinely, she says, throughout history, Congress has been given deference to create some constraints, some protection, some immunity around bureaucratic actors to put them at some remove from the president. I think there's a theoretical point there, right? That is the theoretical point that I think suggests that you want some constraints, whether it's a Democrat in the White House or a Republican in the White House. What do I mean? Public choice theory says you've got concentrated interests who are repeat players, who are big financial institutions who can make themselves felt. They will make themselves felt by giving donations, by withholding donations, by lobbying. They will make themselves felt. And they will make themselves felt in administrations that are Republican, that are administrations that are Democrat. The people like me who get a $458 check, which is what I got, in the settlement of my class action, right? We applaud that. I put it in the bank immediately. But if I didn't get it, I would not have noticed it, right? That meaning, if it doesn't happen, am I organizing with all the other people who have suffered some loss to vote the people out who didn't regulate in my favor? It's very hard for ordinary people to organize themselves in ways that will make themselves felt. And so, right, she seems to make this argument that is, look, we treat financial regulation different. And I think the larger theoretical point is we treat regulatory issues where there's a great capacity to organize as against a set of diffuse interests, right, that don't organize well. We do suggest that they might be more vulnerable, that the political branches might be more vulnerable to a certain kind of capture, again, regardless of political party. And so now that argument is rejected, right? That is the dissent. But the dissent seems to suggest that there are reasons without any regard for who sits in the Oval Office, that we might want to constrain a president's capacity because a president is going to feel that pressure. Politicians are going to feel that pressure. And to the extent that we can create and immunize agency decision-making from at least some of that pressure, then we are going to protect consumers' interests because they don't organize as effectively under any administration, under any set of circumstances. And so, right, that begins to, so she says, this is the sort of theory, in some sense, around why the court historically has allowed Congress some deference, some leeway to create these kinds of constraints on the president.
And she's backed up by the facts. Currently,
Yeah.
there's one person who runs a federal housing finance agency, right? That deals with Fannie and Freddie. And there's one person who's the controller of the currency. Mm-hmm. There's one director of the Social Security Administration. So she's not just theorizing, those are the facts.
Right. And by she, we're saying Elena Kagan in the dissent.
Sorry.
Yes. So let's do something a little weird, which is I just want to, we've talked about the dissent, but I just want to emphasize for a moment, Jen, can you, and I don't want to say in 30 seconds or less, because however long you want, but we've been talking, we've just kind of, the three of us, I think, basically assume Elena Kagan had a point in the dissent. Who wrote the majority? What was the vote? And why did they not see Elena Kagan's way? Basically, what was their conclusion?
So it's interesting. The majority is kind of broken in half. So the half of the majority, so the 5 justices, and it was Roberts who wrote the first half of the majority opinion. The first half said, you're asking us for, given this very powerful agency, you're asking us to make yet another exception to the general rule that presidents need this power of removal. And they just decided no. And if you look at the holding, it says they're very clear to say, we hold that the Consumer Bureau's leadership by a single individual removable only for inefficiency, neglect, or malfeasance violates the separation of powers. They were not going to extend the case law. And as for the recent examples that I just mentioned, they said, yeah, that's kind of new. So it was almost inviting another case to challenge some of these other places that have a single director only removable for cause. So that's half of the decision. So half of the decision said it's not constitutional. But Roberts could not muster with his conservatives a majority to say, let's save the rest of the statute and just like pencil out the removal provision. So he needed to rely on the dissenters. So he only had, I think, himself and then the liberal dissenters on board to say, because what the dissent said is, you're wrong, it's not unconstitutional, but separately, hey guys, if you decide it is, we think it's fine that the whole rest of the statute works without it. So it's a weird kind of combination.
This is like an evergreen statement at least for a while. John Roberts can't get the conservatives, he can't get the liberals, he's kind of on his own. So what we have is, my summary is what we have is a majority that's saying, we're not going to create another exception. The Consumer Financial Protection Bureau, the way it is structured in terms of allowing the director to be fired for a reason is not constitutionally acceptable, because it violates the separation of powers, meaning it violates the president's authority to take care to faithfully execute. And we can't do that, but we're not going to dismantle the whole agency. And that was, at least from my perspective, this is my bias, this was one of my fears, which is it going to be severable? And so it was a fairly, in that way, narrow decision. Charlton, did I see your hand up as I was? Yeah.
So I taught the precursor case to this PHH versus CFPB when it was in the DC District Court and in the Circuit Court, right? Again, from a kind of theoretical perspective, the court says, look, we have granted this to multi-member bodies, right? We multi-member bodies, they have to deliberate, they have to come to some, right? So the exercise of their power is constrained because they have to convince right, 3 of the 5 people on these multi-member bodies to sort of, before they can do anything, right? They said, over at CFPB, if Richard Cordray wants it, then Richard Cordray can get it, right? And that, and they make this argument that, look, the only single-headed branch of the government is the president, right? Because we understand that there are threats, there are risks. Now, we chose to make those, to assume those risks with a president who, a presidency occupied by a single person, but we should not replicate that, right? And so this argument that, right, you can look back to Humphreys, right? The court distinguishes Humphreys by saying, no, that was the Federal Trade Commission, right? That was a multi-membered agency, and this is different. And there's an interesting question here, right? The court the majority seems to suggest that in its focus on the take care language, that this is a question about presidential administration, right? That meaning the removal of an agency head is a question of the president's capacity to administer the agency. Whereas the dissent seems to suggest that a removal provision is really a question of structuring the agency, and that Congress ought to be deferred to in the design and structure. They don't see this as an administration question. They say, look, the president is left with all of the normal administrative tools to deal with the agency. They think this is a question of design and structure. And if it's a question of design and structure, then Congress ought to have leeway. If it's a question of administering the agency, right, the majority seems to say, then it's really the president's capacity to take care. It's the president's capacity to have been vested with the authority, right? And so there's a sort of interesting question, because when you read Kagan's dissent, she's constantly talking about structuring, construction, designing, whereas the majority is talking about kind of a run-of-the-mill, ordinary, making the shop run. And they're saying the president can't make the shop run. It's not a design question.
It's so interesting. So it feels to me like you're saying the majority looks at this through the executive lens and the dissent looks at this through the congressional lens. And that's how they get to these differing opinions. Jen, I was going to ask you a different question, but did you want to follow up on that, or?
Oh, I think it's really fascinating. I hadn't looked at it that way. So.
Yeah, I didn't either.
Yeah.
And I'm sorry to talk over you. It's a little bit of a Zoom delay problem. So Jen, you said, and I want to emphasize this, that the case almost invites further challenge. And so I want to specifically talk so that the audience knows what's next what's next for challenges to executive agencies. Which specific agencies, and we've been mentioning them a little bit, but I just want to emphasize it. Which agencies do we think these are the agencies that might be vulnerable to challenge? Is it just the agencies with one director? Is it also the agencies that have more directors, that have a number of commissioners? And, again, specifically, which are these agencies, and basically what do they do for us?
Yeah, I mean, it's interesting. I can answer in the abstract and then getting really specific. In the abstract, the court on page 16, again, back to those lines of cases. They're like, we've made some exceptions for presidential removal power, but then when they describe those exceptions, they describe them really narrowly. So they say 2 exceptions. One, for multi-member expert agencies that do not wield substantial executive power. That's the first one. So now all of a sudden, if you had a multi-member, so if all of a sudden you, instead of having one director at the Consumer Bureau, you had many of them, and you still, like the other multi-member positions, you could still remove them if they were inefficient and so on. That might not fly with this court if you gave them too much power. So that's really interesting. The second exception would be those inferior officers with limited duties and no policy making or administrative authority. So there we need to think more closely about what are those single directors who also can't be removed but for cause, And I think that's where we invite the challenge by anyone regulated by them to say, hey, they have too much power. They can't come after me. So, and I think specifically it could be FHFA, it could be SSA, it could be control of the currency.
Could you tell us what those agencies are?
So there's this, remember I mentioned a bit earlier that there are many different agencies that regulate banks. So the Office of the Controller of the Currency, you'll see that acronym OCC, regulates what's called national banks. And there's other bank regulators. Some have been abolished because I've done a bad job. So there's that. And then the FHFA, which I mentioned, is in charge of housing finance. So if your mortgage is bought, if you get an FHA loan, that's the FHFA, et cetera.
Okay, thank you. I get lost in the acronyms. I appreciate it. So, Charlton, here's a headline that I kept reading kind of June 29th, before, after, which is, this is part of the dismantling, this decision in SELA law, where the Supreme Court says, no, anybody, you have to be able to fire the director of the Consumer Financial Protection Bureau at will. Congress can't force you to point to a reason. That this is the beginning of the dismantling of the administrative state. So can you start by explaining what is the administrative state? I see this term all over the place. I have a feeling you'll both want to answer this one because it's such a big one, or no, whatever you feel like. Charlton, though, I'll start with you because we've been going up and back.
No, it is a big question. The administrative state, as I sort of explain it, is that which you get when Congress attempts to regulate in response to problems, and understands itself not to be expert, right? To say, look, there are certain factual preconditions that ought to exist before a certain set of regulatory impositions ought to be triggered. And we're not in the business of trying to determine when that is. We want experts to do that. And so we delegate to them some authority to make factual determinations, to try to make policy, to try to implement our policy choices in broad outline, right? And to do that by paying some attention to the statute, by paying lots of attention to the facts on the ground, and we can give them some other sets of authorities, right? They don't all have the same, but in broad outline, it's the institutions that try to implement congressional initiatives, right? Whether that's food stamps, right? Whether that's housing, whether that's education. Congress does not see itself generally as experts, right? The only legislation that Congress tends to take full control of is tax legislation, and tries to write that with a great degree of specificity. But in the main, Congress doesn't legislate that way, and somebody has to implement it, and that implementation comes with some power. And we've been fighting over who gets to control those implementers almost since the beginning.
That was a very, very clear answer to what I feel like is a really complicated and big question. And so, Jen, now to the political aspects of the administrative state. I asked Charlton to explain what it is. Why has this become something that we discuss in political debates? And specifically, it does feel like half of America thinks it would be a good idea to, quote unquote, dismantle the administrative state. What specifically, maybe it feels obvious, but what do we mean by that?
Yeah, I mean, it's interesting. The administrative state is code that means different things to different people. I would say, now people might equate it, sort of conflate it with what cynical folks call the deep state, but it's not. What I think most people meant by administrative state was a lot of the regulations put in place during the FDR era, during the,
Yeah.
not just the FDR eras, there's this, as it was alluded to, whenever there's a crisis or mass casualty, often Congress, using its Article I authority, creates laws to prevent the same bad things from happening. And sometimes when they create the laws, they also create a special agency of experts to administer those laws. So we can think about, when we had the problems with, we have them again, but the meat packing industry, or, and then we get a whole bunch of different laws, and we get the USDA. When you have problems with people being poisoned by quack remedies, oh, we're having that again. But you get the Food and Drug Administration. And so the idea here is these happen at different periods of time. A lot happened during the Roosevelt era, right? And so on the one hand, those are designed to address problems, but they cost money. It's time consuming to comply, and there are penalties for not doing so. And so businesses don't like that. So that can happen. And sometimes regulations don't fit perfectly. And so the ones that don't fit perfectly need to be tweaked. But it gets to be wanting to throw the baby out with the bathwater. The other piece of it is this federalism part, right? The part of the people who want to dismantle administrative state want to go back to a world they claim where states have rights and we don't need any business regulation at all. We can just go back to common law judges making case-by-case decisions, which obviously would empower those with money and power already, because most people can't go through the court system one by one to try to, or if they've already died, from some poisoned remedy, or the plane has crashed. So the idea again is, for those who like the administrative state, it's here to protect consumers, employees, and so on. And for those who don't like it, it's either, I think, because they don't really know the benefits of it, and they perceive, for those who understand it, it gets in the way of their ability to make money.
It feels like I'm thinking back to that song. What is it? Shirley Bassey. It's just a little bit of history repeating when you talked about all of the things that have come back. So with that, I think, Charlton, if it's okay with you, we'll move on to Q&A. I see for both of you, it's actually 9:07. This is, look, as much as I would love to be in a room together, this is the benefit of virtual Hammer Forums, which is we get the two of you, which is really fantastic. I learned a lot about this case, truly. So Emmanuel has a question. The CFPB is not a consumer advocacy organization, ? And Charlton, do you want to take that one?
Sure. So I don't think it is a consumer advocacy organization. I do want to be clear about that. Meaning it is not a member group. It is not. The agency has no greater authority than Congress has delegated to it. It has the authority to work within the statutes over which it has authority to administer, and it writes rules consistent with that authority. And it's and I don't want to minimize the role that protecting consumers plays, because it would have no reason to exist in that sense, right? But what it does is to say, look, as we regulate, we are going to prioritize consumers' interests in a regulatory fashion. But again, we understand generally that agencies acting legitimately cannot act beyond their mandates. And so when one of the big things that the CFPB did was they enacted a rule that attempted to regulate payday loans lenders and vehicle title lenders and other sort of high interest rate sort of installment folks, right, as a way of protecting consumers in terms of disclosure, in terms of imposing real limits, right? Other impositions from a regulatory perspective have been to remove the ability of some actors to impose arbitration agreements on consumers, right? And so to be sure, they have acted, as has been stated, in ways that have furthered protections of consumers, but within a kind of mandate that comes from Congress, right? Whereas, look, if this is AARP or the Consumers Union, right, you are being motivated on some level solely by the interests of your members, whereas the commission has to try to justify its policy choices by the power that it has been given, by the constraints that Congress has laid out, even if only in broad outline.
Yeah. Yeah, that was very clarifying. Thank you. Matthew asked, Jen, I'll give this one to you. We hear about new financial products reported to be nearly identical in every way to the derivative products initially banned in the Dodd-Frank era. What, if anything, is the agency doing about these, quote, faulty products, and what are they doing practically to protect consumers today? There's a lot there for you to answer, but we can maybe start with, what are some of the activities that the Consumer Financial Protection Bureau is undertaking today? Or maybe I'm going to take a little moderator's privilege on this. Is the Consumer Financial Protection Bureau actually fulfilling its purpose anymore?
I'm gonna dodge your question and go to the other question. Try to address that question first, and then go back to yours, which is, the Consumer Financial Protection Bureau, I don't think banned any derivative products, and I don't believe derivative products are really banned under Dodd-Frank. If anything, one of the strongest provisions regarding derivatives in the statute was to require banks to, if they were going to be buying and trading in derivatives, to push them out. It's called the swaps push out rule, to push out certain high risky things they were buying and selling into the non-depository part of their conglomerate. And that was, sneakily in one of these must-pass budget bills. I think it was in 2014 or 2015 that was eliminated. So I'm not aware that all that much was done to save us all from derivatives. But back to your question, is the CFPB fulfilling its function? I think it could do a better job with a different director, honestly.
That's fair. And I see that it's almost 6/9:15, but I have two experts in the room, and I can't let you go without asking about the news of the day. And the news of the day, of course, is President Trump saying maybe we should, a few things, but maybe we should delay the date of the election, or I think he said maybe I should delay the date of the election, which is actually important. And again, kind of the drumbeat of there's voter fraud, you can't trust the vote by mail system. I'd love to hear both of you answer this, but maybe Charlton, to start us off, can the President of the United States change the date of the election?
Absolutely not. Absolutely not. But I think we need to appreciate, and again, this is one of those reasons why we've got to worry about a case like this. That is to say, can the president, in a moment where people are clamoring to vote by mail, undermine the capacity of the institution that is empowered to deliver the mail to us and to get the mail back where it's supposed to be? Can he wreak havoc on that, on our electoral system through some means? A decision like Selah law makes that more possible, right? Now, look, let me be clear. The Hallmark case, you're right. When we talk about the sort of the granddaddy of them all, Myers, right? Myers is a case about the Postmaster General, right? That and the court says this person is a quintessentially executive person. This person can be fired at will, right? So when the court talks about the sort of steady state of affairs, and so I'm worried, right? I think we have every reason to be worried about courts that would read broad latitude into a kind of executive authority that this case represents. No, he can't move the date, but can he mess up and mess with the machinery of democracy? I think so.
Jen, I'll ask you to pick up on this. And, again, so much of what we do, I feel like is really complicated and it's gray area. And this is just, the president does not get to wave a magic wand, right? To unilaterally say, I'm changing the date of the election. But what happens if in an alternate universe, Congress decides that we're going to push back the date of the election? Or is there a scenario in which we don't have an election, where we don't vote? Is there a scenario in which the House of Representatives is involved in this? I think you probably see where I'm going with this, if you want to pick up from there.
Well, I mean, I was surprised and heartened by the fact that the Republican leadership today, Mitch McConnell and Kevin McCarthy over in the House, said, yeah, no. We're, you need Congress. Congress sets the date of the election. So at least from a legal perspective, they're willing to say no to him. But then there's practical on the ground. Is he going to, what if Trump sets fire to the cities? We can all imagine, well, we can all go into these dystopias and imagine what would happen. Now, look, some people have speculated, could Nancy Pelosi then become president? Because in the Constitution, let me just back up and say, if there wasn't a presidential election, the Constitution is clear that both President Trump and Vice President Pence, their terms are over on January 20th at noon. But we shouldn't jump to the conclusion that that would mean Nancy Pelosi, who's Speaker of the House currently, would step into that role, which is the next in line. The only way that would happen would be if somehow there wasn't a presidential election, but there was a congressional election, right? And then you would have on January 3rd, the new Congress, all of them would be then sworn in. And then if the new Congress selected her and there hadn't been a presidential election, then she, as Speaker of the House, would become president. But I think that if there weren't a presidential election and by miracle there were a congressional election, I think this would be a huge, very important decision to make. It wouldn't just be automatically going to her, right? That people would understand that she'd be next in line. I cannot see any of this actually happening, though. That seems, come talk to me in January. But I think the biggest threat we face is, everyone is so eager to vote by mail, but even if there weren't someone undermining the post office, folks, it's confusing. I'm voting by mail in Massachusetts, but the minute my ballot comes, I'm sending it in because you can't wait till the day before, or you're going to have to. So there's a lot of human frailty around everything that's happening around this election. So I would just say to people who are voting absentee or voting by mail, get your ballot in, vote right away. I don't care who you're voting for. If you want your vote to count, get it in the mail as soon as possible.
So I would love to do another forum with you both of you, and I desperately hope that it is not about these. I hope we do not actually confront these specific issues. Charlton, Jen, thank you so much. I learned so much about SELA law, the administrative state, and thank you for indulging me so that we could have that quick conversation about voting and the election day. And I do want to emphasize something. I think I now end every Hammer forum with this, but please do, if you're in a state where you need to register to vote and you haven't, or if you need to request a vote by mail ballot, I should say in every state you need to register to vote, but if you need to request a vote by mail ballot, no time like the present. And again, no reason to delay. And I know that the Hammer will have a lot of informational opportunities for everybody to learn about the ballot in California. I think we have 13 propositions on, and I'm sure that the Hammer will be there to help walk you through all of those. So with that, again, Jen, Charlton, thank you so much. I am going to let the hammer form play us out. And that was just great. Thank you so much.
Thank you.
And I'm going to leave.